Hello, everyone. Today we'll be discussing a very interesting topic that usually arises in estate planning or family matters. And what's this question? Should the property owner notify their beneficiaries after selling their property? The answer to this question is varied and it depends on your situation. We've seen cases where after a deceased dies, the beneficiaries start to challenge actions taken by the deceased during their lifetime. In some cases, the deceased sold their property during their lifetime without notifying their beneficiaries, and you find these beneficiaries challenging the sale by suing the new third party who must have legitimately and lawfully purchased the property. And it's becoming a recurring issue. And in order to avoid this sort of challenge, it's usually important for businessmen or property owners whose family members, immediate beneficiaries, are aware of your assets to notify them when you sell your property. If you don't want to notify them, then aside from preparing your title documentation, transferring title to another party, ensure that there's proper documentation that will make it abundantly clear that you sold the property during your lifetime. However, the best situation is for you to notify your beneficiaries, because if anybody wants to challenge a sale of a property during your lifetime, it would most likely be your beneficiaries. But if you have a situation whereby during your lifetime you are the type who doesn't allow your beneficiaries to know about your private affairs, then you might not have any obligation, or there might be no need for you to disclose the sale of your property to your beneficiaries. But ensure that you keep proper documentation that will make it abundantly clear that you have sold this property. And how can you keep this sort of documentation? If you transfer your property to a new buyer during your lifetime, you can create a file for the property in your safe and put all the documents, evidence of transfer in the file. Also note it there, I sold this property to this person on so date, and the person paid to this particular account. Keep it there. So, and make sure another third party is aware, because if the third party is aware, that third party will protect your legacy and your reputation if any of your beneficiaries decide to challenge an action that you took during your lifetime. So, in summary, one of the ways to avoid our beneficiaries having needless litigation after our demise is to let them know whenever we sell an asset, or we should make it abundantly clear that we've sold the asset. Because we've indeed seen cases where a party dies and the beneficiaries find a copy of the certificate of occupancy, or even the original copy, in their father's closet or their mother's closet. However, the mother has sold the property during her lifetime, but at the time of the sale, she couldn't find the title document. And you find these beneficiaries challenging an innocent and lawful buyer. So if we don't want this sort of thing to arise regarding our estate, we should transparently communicate with our beneficiaries or take steps to make it abundantly clear that we've sold, such that if there's a case that arises in the future, the new buyer will be well protected. Thank you very much.